Mr. Freiberger was removed from the public comment chair during the January board meeting by Chairman Benyon because he referenced our prosecuting attorney Jim Thomas's remarks ascribing to Dr. Holmes the term disingenuous at best. He was referring to this email string between Trustee Corker and Superintendent Holmes. It began with Trustee Corker asking Superintendent Holmes the reasons for the hasty renewal of her contract. Dr. Holmes never did answer that. However, she did say, there is a tape brought forward by a whistleblower that is of a meeting that claims to be in violation of open meeting law. The tape includes you, among others, talking about an upcoming agenda item. Trustee Corker says, please answer the questions I posed yesterday, and of course, please disclose immediately the nature of the violation so that I may cure it. Dr. Holmes says the audio recording is approximately the last two-thirds of the meeting held on October 29th at the district office with various people. Trustee Corker says thank you for your response, repeats her questions, and then says, please email me the audio file of the meeting with the group, and who taped the meeting? Was it an employee of the district? Who ordered the meeting taped? And were you aware that the meeting was being taped? Dr. Holmes replied, I indicated to you I would be glad to have a conversation, but this is privileged information and I'm not willing to put it in writing. Please call. Regards to the audio recording. It's too large for an email. I'll see if I can find a thumb drive to put it on. I did not know the meeting was being taped, nor am I aware of anyone ordering it. To tell you anything about the whistleblower would be a violation of federal law. And Trustee Corker replies, of course, I appreciate the offer to put the audio recording on a thumb drive, and I will pick it up at the front desk. Dr. Holmes replies, it is there waiting for you to pick up. This sentence, I did not know the meeting was being taped, nor am I aware of anyone ordering it, then initiated an investigation or a continuance of an investigation and eventually a discontinuation of that investigation by local police. Prosecuting attorney Jim Thomas responded to a public records request from Ms. Pamela Plowman asking for his email correspondence concerning this recording incident with certain Blaine County School District personnel. Mr. Thomas replied with the requested information without charging a fee and within the legal time frame, contrary to BCSD response, which wanted $3,200 and initiated our citizen lawsuit. Jim Thomas says to Chief Gunter, based upon previous conversations, I know you believe a personnel conflict of interest exists that prohibits you from investigating involving school administration officials. From my legal perspective, based upon the information in the attached emails, I believe it is unnecessary to seek appointment of an independent law enforcement agency to investigate this allegation further. Dr. Holmes states she has standing instructions to allow her staff to record her communications when she is in a, quote, contentious meeting, unquote. Based upon the representation that she previously authorized administrative assistants to record her meetings, I do not believe a subsequent lengthy and expensive investigation would lead to sufficient evidence necessary to successfully prosecute this case. I make this decision notwithstanding an email exchange with school trustee Liz Corker, whereby Dr. Holmes denies knowledge that the meeting was being taped or was aware of anyone ordering the taping of the meeting. Certainly, if Dr. Holmes did give prior consent, as she states in her exchange with Assistant Chief Stellers, then this statement to Liz Corker is disingenuous at best. However, I believe this matter is more about trust and professional ethics as opposed to criminal conduct, and should be handled in the appropriate public forum, not a court of law. Anyone who disagrees with my opinion is free to take the matter up with the Idaho Attorney General's office and seek their input. He includes then the emails from Dr. Holmes to Dave Stellers' Hailey Police Department. Dave, the administrative assistants at the BCSD office have long-standing instructions from me on how to support me in contentious meetings in our office. Please notice the date of this is January 8th. Her emails to Trustee Corker were in early December. Then she goes on to say these instructions include that I always will leave the door open so they can hear and intervene when needed. If the meeting is heated, they are to do any or all of the following: take notes, record the meeting, step in and stop the meeting, or call me out, or call for security. So she indicates that this was a contentious meeting. However, the recording, which is available in response to a public records request, has nothing contentious about it. And then a follow-up from Attorney Adam King saying the same thing, that Gwen Carroll Holmes has had long-standing instructions, long predated the meeting in question, to listen, record, take notes, etc. So Adam followed up, and consequently, Prosecutor Thomas told the Hailey Police Department, in his opinion, it was not worth pursuing, and that's where the phrase disingenuous at best came into being, which Mr. Freiberger quoted at the board meeting, which caused him to be removed by the police officer at the request of Chairman Benyon. Worth noting the difference between his mild-mannered quoting of our prosecutor and Ms. Stone's repeated personal naming attacks on two trustees. Why is there such a difference?